Hey, death penalty class. So this is video number 1. Now here's how this is going to work. These are going to be posted every week, a couple each week, and you can watch them at your own convenience, okay? My advice is to open up the PowerPoint slideshows and follow along as I talk. You don't have to do that. Definitely look over the PowerPoint slideshows on your own, maybe first, and then watch the video with it. But each one will sort of pertain to a slideshow that I'm putting online for you as well as part of your notes. So this video deals with the history of the death penalty in general. There'll be a much briefer video about the history of North Carolina's death penalty. I just want to highlight some of the key facts and explain some of the key issues that you need to understand over this semester. So let's start with the definition of the death penalty. If you're opposed to the death penalty, you might call the death penalty murder, which I understand. However, it's not the same thing, because murder is an unlawful killing. The death penalty, where legal, is obviously a legal killing. So the definition of the death penalty or capital punishment is the infliction of death by the government as allowed by law for the commission of a capital crime. Now, currently, the only capital crime that the Supreme Court will likely allow someone to be executed for is capital murder. Okay, so treason is a death penalty offense. Being a drug kingpin is a death penalty offense at the federal level. But you'll see when we go through the death penalty law that the government will not allow, the Supreme Court in particular, will not allow a person to be executed unless someone has been killed. And the term aggravated murder is a legal term that we'll see later. It basically means that aggravating factors outweigh mitigating factors. Now, we're getting ahead of ourselves a little bit, but aggravating factors in the law are factors that make the murder worse. Mitigating factors are factors that make it less worse. We'll get to that when we get to the law unit coming up. But that's what aggravated murder means, okay? If you're curious about those, you can go ahead and look them up in North Carolina. The aggravating factors and mitigating factors are listed by statute, so you can look those up in the North Carolina statutes. Okay, you're going to see 4 major time periods according to death penalty scholars. I've added a 5th, okay? The first is the colonial period. That's when the country was founded. The second is the 1800s, or the 19th century. The third is what's called the progressive era. That's the early 20th century where we saw some significant changes with the death penalty. The fourth is the modern period. That's the late 20th century, the late 1900s. And then the newest one, the 5th, is the contemporary period. So you'll see me talk about the contemporary death penalty. That's the 21st century, and it's really the past since 2007, when states started abolishing the death penalty pretty rapidly, as you'll see. Now, here's why these periods are important. Each of these periods, each of these eras, is marked by significant changes in death penalty, the law, how it's practiced, and even public opinion. So you'll see 6 specific points that are made in the PowerPoint slideshow about the changes. So from the founding of our country, the colonial period, till now, here's what's happened. We've gone from brutal executions, excessive executions, public executions, to clean, detached medical executions that are conducted in private. We went from hundreds of death-eligible crimes to just a few, and really one, aggravated murder. We went from hundreds of executions per year. You'll see the peak in 1935, and an average in the 1930s of 167 executions. You'll see that later in the slideshow. To just a few, or really just dozens of executions per year. We went from a few countries that had abandoned the death penalty to more than 100, so a majority of countries in the world no longer practice this. We went from a few states that abandoned the death penalty to almost half of the states in the United States no longer use it, as you'll see later. And then, perhaps most importantly, we have greater efforts to ensure the death penalty is fair and rational. So you'll see a term called super due process throughout the semester. You know what due process is in the Fifth Amendment. It's the efforts to assure your rights, the constitutional rights are protected, right? And that everyone's treated fairly. Justice is blind, for example. So everyone receives the same justice. Super due process are extra protections that are given to death penalty defendants. Things like 2 lawyers, one lawyer with death penalty experience, an automatic appeal to the Supreme Court of the state, what's called a proportionality review, where the death sentence is reviewed and compared to other cases to make sure the death sentence is appropriate. These are things we'll get to later in the law section, but that's what I mean by greater efforts to ensure the death sentences are fair. Now, what does this mean? That's one of the things you'll be asked to try to figure out for yourself, just your educated opinion. Are we getting soft on crime? Are we just becoming a more decent people? Are we becoming more humane? Or is there something else going on? Now, the rest of the slideshow deals with some key facts and some important facts. So, for example, in 1608, you'll see the first ever execution in the United States documented. George Kendall, who was executed for spying for Spain in the state of Virginia. Now, others say it was a guy by the name of Daniel Frank in 1622 who committed the crime of theft. But what's interesting is whether it was spying or theft, these are crimes that people don't get executed for anymore because, again, it has to involve an aggravated murder. Okay, but you'll see a list of early capital crimes. Pretty fascinating stuff. Striking a parent, denying God, stealing grapes, killing a chicken, trading with a Native American, all kinds of sex crimes. So again, we used to be a lot more punitive. Now in the colonies, the Puritans were far more punitive than the Quakers, so you can read about that. Quakers believe in peace, for example, in all areas of life. But even early America, as punitive as it was not as punitive as England. So click on the link, read about the England Bloody Code, 222 crimes for which you could be executed in England. Now remember, our country came from England, so of course we brought a lot of our justice and a lot of our traditions from England. That's called custom law, or customary law, or common law. So the death penalty is one of those things we brought over from England. Now you look at the next slide is the number of executions. This comes from the SB file that's linked online. It's a file of all executions in U.S. history. We've executed more than 23,000 people since the 1600s. You'll see the peak there in 1935. 199 people executed that year. That's the most we've ever done in 1 year in recorded history. Now in the 1990s, we got up to another high of 99, but that's far below that high of the 1930s. Okay. Now we're averaging something like 35 per year. You'll see that as we move on. Okay. So we've gotten a lot softer, if you will. Now, of those people we executed, 97% are men. Why is that? Because men commit most of the murder, as you'll see. 98% are adults. It is no longer legal to execute a juvenile. That is, if a person commits a murder at age 16 or 17, they are no longer eligible for the death penalty. We'll get to that when we talk about the law again. You'll see that. Now, why was the death penalty carried out early on? Well, for the same reason it is today. Two reasons you'll see. One, crime prevention. So deterrence and incapacitation deals with crime prevention. Incapacitation is taking away someone's freedom, in this case permanently through the death penalty, so they can't commit another murder. And deterrence is the idea that if you execute someone, it creates fear in others, like would-be murderers, so that they're less likely to commit murder. Those are both crime prevention. Retribution means getting even, balancing the scales of justice. So if you take a life, you pay back the government with your life. That's justice for the victim and justice for the family members. That's what the death penalty was meant to be originally, and that's what we hope it is today for those states to carry it out. Some other key facts. In 1642, you see the first execution ever of a juvenile, and he was executed for bestiality, having sex with an animal. Don't really know what kind of animal it was, don't want to know, but you can look up his name. It might be in the recorded history. The youngest person we executed was a 12-year-old in 1786 in the state of Connecticut for the crime of murder. Again, 12-year-olds can no longer be executed today in contemporary America. Now, you'll see the abolition movement, the movement to abolish the death penalty actually started very early in America. So some of the signers of the Declaration of Independence were for abolition. They viewed it as unnecessary or immoral or unjust. So you'll see a president, an attorney general, one of the founders of the country as well, or abolitionists. Now here were their successes. Number one, the establishment of penitentiaries. Penitentiaries were early prisons. They're called penitentiaries because it was meant to give the offender the opportunity to offer penance or to pray for forgiveness and ask for forgiveness from God. That's a corrections class that you should take if you're interested in that, which I'm sure all of you have taken. But also degrees of murder were established. So first degree murder is worse than second degree murder, which is worse than third degree murder, which is worse than manslaughter. I'm sure you're familiar with those terms from a criminal law class. The death penalty was no longer mandatory, but it was discretionary. So prosecutors, if they seek the death penalty, it can be imposed, but they don't have to seek it. It's discretionary. And then less death penalty overall. So these were actually successes of the abolitionist movement. The first states that abolished the death penalty were in the 1790s. Most of those, however, would reinstate it, and you'll see this in the slideshow. What tends to happen in U.S. history is if there's a really heinous crime in a state, particularly against a particularly vulnerable victim like a child, the states will often reinstate it. They'll do away with it, but then bring it back. Now that means if you're an abolitionist, if you want to abolish the death penalty, you should also simultaneously work to reduce murder, because it's in your interest not only to reduce murder, but also if you want to abolish the death penalty, you need to make sure these heinous murders don't happen, because that's what tends to bring back the murder, or excuse me, that's what tends to bring back the death penalty. Okay. The first state to hide executions was Pennsylvania in 1834. The first discretionary death penalty statute was Tennessee in 1838. That means that the death penalty was not mandatory. Now that becomes important for North Carolina later. In the next video, you'll see me talk about that, because in 1976, our mandatory death penalty statute was struck down by the Supreme Court in the case of Woodson versus North Carolina. We'll get to that later. The first state to abolish the death penalty for all crimes except treason was Michigan in 1846. The first to abolish it for all crimes was Rhode Island in 1852. So you'll see that 9 states abolished the death penalty in the early 20th century, and 3 others limited it to few crimes. Now this is what's happening now. You're going to see from 2007 to 2020, a whole bunch of states have abolished the death penalty as well. So we'll get to that later. The first, so historically, executions were carried out by local governments, and it was done in the county where the crime was committed, for example. So this allowed the victims to be present, the victim's family to be present, community members. These were public executions, and so it was more immediate and just because you could see it happen, right? Carried out in the name of your loved one who was murdered. But the first person executed by the federal government was Thomas Byrd in Maine for murder, and the first person executed by state government was Sandy Kavanaugh in Vermont. So one of the things that you should try to understand is, how did executions go from local to state and federal government? We'll talk about that as we move on. Now, these early executions, as I mentioned, were public, and they became private in the late 19th century, the late 1800s. Why? Well, historians disagree, but you'll see if you look this up that there were rowdy crowds. So public executions were meant to be somber events, educational events meant to deter people from committing murder. They were very religious in the sense that they gave the opportunity of the crowd to pray for the soul of the condemned. So even though it's a bad person who committed a bad act, they were worthy of eternal salvation if they just said they were sorry and renounced their sin. But people started showing up drunk. People started partying. People were even committing capital crimes in the crowd, pickpocketing, theft, and things like that. These were often capital crimes at the time. And so this just left a bad taste in everyone's mouth. And this is part of the reasons why we had to have private executions. And then, of course, executions moved to fixed places. So this is where we start seeing the transition from local executions to state executions. So, for example, in North Carolina, instead of it being like an execution in Watauga County, it would move to a central location of Raleigh. And so all executions would be there. So this means often your victim's family members would not be present. It would be private behind closed doors, and only certain witnesses are allowed, and they're selected by the state. We'll get to that later when we talk about the death penalty in North Carolina. In the 1930s, the government started keeping detailed statistics, and we see the most people killed per year. The average in the 1930s was 167 executions. The most in 1 year, as I said, was 199. Now we're down in the 30s per year, something like that. So we've fallen a lot. The last public execution, you'll see a picture in your slideshow in Owensboro, Kentucky. Look at the crowd. This was a public hanging. Thousands and thousands of people showed up. Now, you might think that in this case it would be a deterrent, right? Or if we put it on television, it might be a deterrent. But the odds are it probably just turned into a new form of entertainment, right? This is what we like. We have a lot of crime shows, murder shows on TV already. We find it very entertaining. We have very violent movies that we watch and video games that we play where you can kill people. It's probably just going to turn into another form of entertainment should that ever happen. By 1950, 70% of those states that had abolished the death penalty reinstated it, but its use began to decline. So you'll see the numbers in the slideshow. From 1,289 executions in the 1940s down to only 120 between 1977 and 1989. Public opinion turned against the death penalty in the 1960s. So you'll see the only time in recorded history where more people opposed the death penalty than supported it was in the late 1960s. And now there's a big gap, right? And actually that gap has shrunk in more recent history. So in 2020, the portion of people who support it versus the portion of people who don't is very small. And in fact, the majority of people now actually, when given a choice, opt for life imprisonment without the possibility of parole. We'll talk about that as we go forward as well. Now, what happened in the 1960s? First of all, you have the Civil Rights Movement. Civil Rights Movement was a major challenge to authority, right? It was seeking equality for all people, black, brown, etc. And so anytime there's a challenge to state and government authority, there's going to be a move to stand up to the government. This would include the death penalty. You also see some very specific challenges to the death penalty in the 1960s. So Carroll Chessman, you can read about his case. He's a very intelligent, educated man who wrote books about the death penalty while on death row to expose Americans to the realities of it. Gerald Gottlieb also argued that the Eighth Amendment prohibited the death penalty because it violates moral standards. Now listen, this becomes important later when we talk about the constitutionality of the death penalty in the law section. The Eighth Amendment bans cruel and unusual punishment. But the founders never defined what cruel and unusual punishment meant. Well, what people thought was cruel and unusual at the founding of the country is different than what people think now. So you'll see the Supreme Court basically read into the meaning of the Eighth Amendment, and they said that what is cruel and unusual evolves over time. So, in other words, things that used to be normal, like executing juveniles, becomes cruel and unusual later, or executing people with quote-unquote mental retardation, which is the term we used to use, was fine at one point, but it's no longer fine today. So our standards evolve based on what states and citizens believe to be moral, okay? Interestingly, in 1961, Walter Oberer challenged the death penalty and said death-qualified juries were unfair. Now, again, we'll see this when we get back to the death penalty law unit. But a death-qualified jury is a jury that is qualified to sit in a death penalty case. Now, this is what happens today. If you're called for jury duty in a death penalty case, if you are opposed to the death penalty, you're not qualified to sit on the death penalty trial. You'll be excused if you refuse to consider the death penalty, because the state has the right to have its day in court and have its penalty imposed as well. So, what we know is death-qualified juries are not only more likely to impose a death penalty, they're also more likely to convict people of murder. So they're conviction prone. He argued that this was unfair. It turns out it's true, but that challenge was rejected in the 1960s. Support hit an all-time low of 42% in 1966, and then the United States just stopped executing people in 1967. So we have an unofficial suspension of the death penalty in 1967. Now, 5 years later in 1972, the death penalty was struck down as unconstitutional. Now, I'm not going to go into details here because we'll go into a lot of details in the law section, but here's the brief version of it. In the case of Furman versus Georgia, the death penalty was struck down as unconstitutional because of how it was applied. There was no evidence that it was arbitrary. There was no evidence that it was biased by race. But because of the possibility of this, the death penalty was struck down by the Supreme Court. So here's what happened. States changed their laws. North Carolina imposed a mandatory death penalty. That was struck down in 1976 in the case of Whitson versus North Carolina. We'll get to that. More importantly, states like Georgia made what's called a discretionary death penalty, where juries were given guidance about who should live and who should die based on legal factors like aggravating and mitigating circumstances, which I mentioned before. The Supreme Court, without evidence that this would fix the problem of arbitrary death sentences, approved that, and so now the death penalty became legal again. And so states quickly started providing legal guidance, aggravating and mitigating factors about who should live and who should die. This was upheld by the Supreme Court. So Gary Gilmore became the first person executed after this in 1977. And you read about him. He eliminated all his appeals and requested to be killed. His brother has been interviewed many times in the media about how ironic that was, that the gift his brother gave to the United States as a murderer was a return to the death penalty. So, but the point is, from 1977 till today, it's considered the contemporary death penalty. So you'll see a lot of the evaluations that we'll do in this class about the death penalty go from 1977 to the current day, or 1977 and 2006. Now here's why. 1977 and 2006 is the first 30 years of the contemporary death penalty. It's also the last year, 2006, that North Carolina had an execution, which is surprising because we've been historically a leading state in the death penalty. So a lot of the data stop in 2006 for that reason, because we have to talk about North Carolina. That's the last time we had an execution. That will be explained later, why we stopped. The last serious challenge to the death penalty legally was the case of McCleskey versus Kemp. Now let me just back this up real quick. We'll spend more time on this when we talk about the law unit. Here's what happened. The Supreme Court struck down the death penalty in 1972 because of the possibility of arbitrary sentencing. No evidence of it. They reinstated it in 1976 because supposedly giving juries guidance about who lives and who dies eliminates the possibility of arbitrariness, even though there's no evidence of that actually admitted in the court. Arbitrary means random, freakish, right? Or racial bias. McCleskey versus Kemp. This guy, Warren McCleskey, proved in court through statistical analysis that the death penalty was biased against black people and against killers of whites in the state of Georgia. So there's proof of arbitrary sentencing. And yet the Supreme Court upheld the death penalty in spite of the actual proof. Now, this becomes important when we look at the issue of consistency and Supreme Court decisions. So you'll read a paper and you have a writing assignment about why the Supreme Court was inconsistent and what that means. We'll get to that later, okay? So look at the difference between 1930 and 1967. We had 101 executions per year. And to the contemporary era in 1977 and 2019, 35 executions per year. This is super due process. The death penalty is more rare because death penalty defendants have more rights. It's harder to impose a death sentence. It's harder to carry out an execution. We'll understand that as we go through the class. So there's a picture in your slideshow. It's slide number 21, if you're interested. You see this huge increase in executions from the 1980s to the late 1990s. And then this huge decline. This figure comes from the Death Penalty Information Center, by the way, which is, you'll have a lot of readings on there. And this huge decline from the 1990s to 2017, 2018, 2019. So what I'm going to argue is what made executions go up is what made it go down, okay? There are factors in the law that made the death penalty go up. There are factors in the law that made it go down. You'll see that as we move through the class so that you'll understand this trajectory. Now, this century, your lifetime as you've been a living, breathing adult and young, well, adolescent child, okay? From 2007 to 2020, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 states abolished the death penalty. Why? This is going to be one of your assignments to find out why. Why did these states abolish the death penalty? You just Google these names and find out, read quickly news articles about why they abolished it. Now, Nebraska abolished it in 2015 and about a year later reinstated it. That's interesting. But the others have abolished it and just done away with it. The case of Illinois is really interesting. You have a conservative Republican governor who supports the death penalty, who abolished the death penalty in the state of Illinois in 2011. Fascinating case. Colorado, 2020. This is a state that legalized marijuana, and now they've abolished the death penalty. Are they going soft? Are they lost their mind? Are they going liberal? Or is there something else going on? You can read about it and make up your own mind what you think, okay? Look at North Carolina. It's slide number 23. This is the number of executions from the 1980s till the current day. You see kind of sporadic use of the death penalty in the 1980s and 1990s, and then we had this big increase in the 2000s where we were in the top 10 in the United States for the number of executions we carried out per year. And in 2003, we were number 3 in the country, so we got a bronze medal. If there was an Olympics for executions, the state of North Carolina would have got a bronze medal in 2003. And then all of a sudden, we stopped committing executions in 2006. Not one since. That's 14 years without an execution. We went from a top 3 state to none at all. So what happened? You're going to see this when we look at North Carolina. You're going to see the specific reasons why. You're going to read a document about what happened that I wrote for the ACLU of North Carolina. You're going to see a video that I made that summarizes the research. That will be next, okay? Now, reach out to me with questions. Utilize your student forum as well to interact. You guys can talk about this. What does it mean? What's important? Stuff like that. Okay, that'll be part of your grade. And I'll see you on the next video.